Hello, Doug Richards here for U.S. Law Shield, coming to you from my Denver, Colorado office. Excited to talk to you today about the Castle Doctrine. The Castle Doctrine is this very special law in Colorado that provides immunity to you if you use your firearm and discharge it in very specific situation. So that would be if somebody is unlawfully enters your house and they're doing something in addition to the unlawful entry, such as stealing some property or something like that. Also, the person has to be doing something where you feel that they're going to use either force against you or somebody else. Doesn't have to be a lot of force, can be just a little bit of force against you or somebody else. In that situation, if those facts are all lined up, you have the ability to use deadly force against that person and have immunity against prosecution. Okay? This is different than going to trial and asserting your self-defense rights. You always have that ability to do that. And that happens all the way at the end of the case. So you've been arrested, you've gone to court a bunch of times, you set the case for trial, you have maybe some hearings in advance of the trial, you go to trial, there's a prolonged jury trial, at the very end of the case, I'll argue the self-defense instructions and hopefully we get an acquittal. That's one way of getting you out of this. The other way is this Castle Doctrine, and it is filed as a pre-trial motion. So you don't have to go through the song and dance of all these court appearances and the trial. That all is eliminated by the Castle Doctrine. The Castle Doctrine is a pre-trial motion to dismiss, and if granted, you have complete immunity against criminal and civil prosecution. It's a fantastic law in Colorado. If, however, you lose on the Castle Doctrine motion, doesn't mean you can't still raise the self-defense issues at trial. It just means you're going to have to go through the time and expense of a trial. The Castle Doctrine only applies in your house, so it does not apply in your vehicle, and if you're living out of your house or even in an RV, it is, I would submit, inapplicable. Now, doesn't mean I wouldn't make the argument, but I don't think that we would win that on the Castle Doctrine. We would still, again, be able to use the argument of the self-defense instructions at trial, but I think you would be precluded from being able to assert that on a pre-trial motion using the Castle Doctrine. If you have any questions about the Castle Doctrine, feel free to give us a call here at my office. Always excited to talk about these issues with U.S. Law Shield members, and I hope you have a great and happy summer.